Welcome to the HR Toolbox, the podcast where we help you build your toolbox of resources, best practices, and strategies shaping the world of HR and business today. Whether you're an HR professional, small business owner, office manager, or someone wanting to learn more about today's work environment, we're here to help. Each episode, we take a dive into our HR Toolbox to bring you an in-depth look at a different HR topic, regulation, or business solution. Send us an email at hrtoolboxpod@gmail.com to suggest a topic or resource tool. The HR Toolbox is here to help businesses stay compliant and competitive. I am your host, Amy Alden. I am committed to your business success one tool at a time. Let's dive in and see what we find in our HR Toolbox this week. Coming up on the calendar, February 20th is National Leadership Day. National Leadership Day celebrates the leaders who inspire, guide, and motivate others. The observance aims to empower people to lead with integrity, making a positive impact on the lives of others. By celebrating this day, we honor those who have made significant contributions and inspire others to step up and lead with purpose and dedication. Also coming up on the calendar, February 15th through the 22nd, is National Entrepreneurship Week. Entrepreneurs play a crucial role in the economy, contributing to job creation and innovation. According to the Small Business Administration, their data shows that small businesses have historically applied for a large portion of patents. Businesses with 5 to 9 employees receive more patents per employee than any other business, and nearly double the patents received by large businesses in 2016. And small businesses employ almost half of Americans, so make a point to shop at a small business this week. February 21st is National Caregivers Day. According to the AARP from Statistics from Caring in the U.S. 2020 research report, 1 in 5 working Americans also assist in taking care of a disabled or elderly friend and relative. 75% of those individuals also work full-time, meaning 30 or more hours per week. And 61% of them experience work difficulties as a result of their role as a caregiver. These difficulties become exacerbated when the individual is the primary caregiver or if they live with the person that they care for. Most caregivers that left their job noted that they did so to have more time to care for their loved ones, and 15% of them left because their job didn't offer the flexible hours that they needed. Many people don't tell their employers about their caregiving responsibilities out of fear of seeming less committed to work or maybe missing out on opportunities or promotions. Verbalizing the importance of caregivers can help eliminate this fear, offering benefits like flexible work hours, caregiver leave, and access to programs for caregivers can make it easier for them to maintain their job and their duties as a caregiver. Those programs can include resources on accessing respite care and backup care assistance, information for online professional consultations, and details on resources available through an employer's health insurance provider. Did you know that it's time to post the OSHA 300A form? From February 1 to April 30th each year, the OSHA 300A form needs to be posted in your workplace. This form gives an aggregated summary of the number of recorded work comp cases, days away from work, or days on work restriction, as well as the category of injury. Make sure that the form is posted in a conspicuous place in the workplace. Our definition of the week: Department of Labor. The United States Department of Labor is one of the executive departments of the U.S. federal government. It is responsible for the administration of federal laws governing occupational safety and health, wage and hour standards, unemployment benefits, reemployment services, and occasionally economic statistics. This week, we are covering the laws and regulations that are newly in effect for 2025 in California. Now, for those of you not in California, yes, we know we have a lot of employment laws. It is not a joke when they say that any HR practitioner in California is an expert in HR. There's a lot to keep up with. But if you are not in California, it's still good to be aware of the employment law changes here, as you tend to see them start being passed in other states. Some states more quickly than others, but it gives you an idea of what could be changing. So let's go through the 2025 California employment law updates. On our compliance posters, we will have noticed that there were a couple of changes. The notices that were updated were the California Wage Theft Prevention Notice, the Minimum Wage Notice, the Workplace Discrimination Notice, the Transgender Rights in the Workplace Notice, Rights under USERRA Notice, and the Cal-OSHA Safety and Health Protection Notice. California's minimum wage increased from $16 to $16.50 in the new year. Now, we do want to note that in California, certain localities, locations, and certain industries like fast food and healthcare have their own wage requirements. So we want to make sure that even though the state hourly wage went to $16.50, certain areas and industries are going to have different minimum wages. With this, the salary threshold for overtime exemption also increased to $68,640. The new Assembly Bill 2299 required that the Labor Commissioner develop a model list of employers' rights and responsibilities under the whistleblower laws. The law requires employers to post a list of employees' rights and responsibilities under California whistleblower laws. The state's Division of Labor Standards Enforcement has made available a poster that it says meets all of the law's requirements. The whistleblower protections prohibit employers from making, adopting, or enforcing a policy that prevents an employee from disclosing violations of a state or federal statute or a violation or noncompliance. It also prevents retaliation against an employee who makes such a disclosure. Now, the poster that the Division of Labor Standards Enforcement has made available is available on their website, with the website noted in the show details. With this, we do want to note that if you are printing this out, it is required to be printed on legal size paper. If you printed it smaller, they're going to deem that it is not compliant. So just FYI, legal size paper there. There were changes to the paid family leave under Assembly Bill 2123. Previously, California allowed employers to require employees to use up to 2 weeks of any accrued but unused vacation time before receiving paid family leave from the state. The Assembly Bill 2123 eliminates that option. Employers may no longer require employees to use up to 2 weeks of accrued vacation time before they can collect the PFL benefits. Following the lead of 10 other states, California passed Senate Bill 399, which is the California Worker Freedom from Employer Intimidation Act. This was created to protect employees who decline to attend employer-sponsored meetings about political or religious matters or information sessions regarding labor organization. Now, I do want to note that this Senate bill does not prevent employers from holding meetings about politics and religion. The only thing that this law does is prevent the forced attendance to an employee who does not want to attend those meetings. So, if an employer offers a meeting on a political or religious topic, it's important to document that anyone who attended did so of their own volition. Now, I do want to note that several business groups have already filed a federal lawsuit challenging the constitutionality of SB 399. They are arguing that the law infringes on employers' rights to free speech and equal protection under the First and 14th Amendments of the U.S. Constitution. Now, again, this law is not preventing any employer from holding meetings about politics or religion. It just enforces that you cannot have a captive audience, meaning you do not allow employees to not participate. But while litigation is pending, you do need to consider whether it is in your organization's best interest to make such meetings voluntary. Now, we also want to note that the National Labor Relations Board recently ruled captive audience unionization meetings. That one's going to take me a little bit. Their law says that it is not legal for employers to force employees to attend meetings on labor relations and union organizing. Senate Bill 88, also known as the Freelance Worker Protection Act, was created so that freelancers, or a person who is a bona fide independent contractor receiving at least $250 from an employer or hiring party, has a written, legally compliant contract. That written contract would include the name and address of each party, an itemized list of services and their value, the rate and method of compensation, when payment is due, or the mechanism for which determining when payment would be due, and when the freelancer must submit an invoice to allow for timely payment. Now, we do want to note that if you are the company hiring a freelancer, you are considered the hiring party, and the hiring party is the person responsible for providing that written contract, and that you must retain that contract for 4 years. The bill was created to have lots of protections for freelancers and independent contractors. It authorizes an aggrieved freelance worker to bring civil actions to enforce the protections under the Senate bill. The Victims of Violence Expanded Protections, or Assembly Bill 2499, expands the list of crimes for which employees can take time off, and it also allows employees to take protected time off to assist family members who are victims of a specified crime. Now, I do want to note that they also broadened the definition of victims to include a victim of a qualifying act of violence, which means regardless of whether anyone is arrested, prosecuted, or convicted of committing a crime, does not mean that a person is not a victim. The law also allows that victims of crimes can use state paid leave for purposes needed in order to attend to items caused by such a crime. Senate Bill 1100 has to do with driver's license requirements and job postings. So California has said that employers who indicate on their job posting that a driver's license is necessary for the job must be able to show that they reasonably expect that the duties of the position require driving. So California says that you cannot include statements on your job advertisements, job applications, or other employment materials that indicate that an applicant must possess a valid driver's license unless the employer can prove that 1, it reasonably suspects driving to be one of the job functions of the position, 2, that they reasonably believe that using an alternative form of transportation, maybe biking, walking, or a rideshare service, or even public transportation, that does not require a driver's license would not be comparable in travel time or cost to the employer. This was made to eliminate a potential employment barrier for some workers. We do want to note that the driver's license requirement is for the position itself. This does not prevent an employee from using alternative forms of transportation to get to and from the workplace. This is strictly looking at the duties of the position and whether or not that duty requires driving. There is also an amendment to the Unruh Civil Rights Act with Senate Bill 1137. This showed that different forms of inequality can operate together, exacerbate each other, and can result in amplified forms of prejudice and harm. So this shows the intersectionality of non-discrimination protections. When we talk about non-discrimination, we show that we should not in the workplace or anywhere discriminate against race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, age, sexual orientation, reproductive health decision-making, or veteran or military status. So how does the intersectional non-discrimination protection work? Using myself as an example, I would not have to show that all people over the age of 40 are being discriminated against, as well as I would not have to show that all women in my workforce were being discriminated against. I could successfully allege that the bias is based on the fact that I am both an older person and a woman, for example. So we're showing that different forms of inequality operate together. We want to make sure that employers revise their policies to anticipate that discrimination can be on the basis of a combination of factors. Additionally, we do want to note that Assembly Bill 1815 has an amendment to the definition of race. And under that amendment, race is now defined as inclusive of traits associated with race, including but not limited to hair texture and protective hairstyles. Protective hairstyles includes but are not limited to such hairstyles as braids, locks, and twists. So we need to make sure that we know that the definition may impact existing policies dealing with acceptable dress and appearance in the workplace. And we want to make sure we amend those to not in any way discriminate against protected hairstyles. Assembly Bill 1870 expanded some information on the work comp notice. Specifically, it expanded the requirements to include notice to an employee's rights to consult a licensed attorney, and that attorney fees may be paid from the injured worker's award through the work comp claim. Now, I do want to note that as of right now, if you're using the State Fund or California Division of Worker Comp PDF, that it does show that the right to consult an attorney is listed on page 3. But I also want to note that that form shows that it was last revised in January of 2016. So even though it does show that the employee has the right to consult a licensed attorney, I would keep your eye out to see if that form is updated further. As of now, though, on your compliance posters, there was an update to this specific section, so your notice that is posted should be accurate. PAGA reforms. I know PAGA is something that makes a lot of people's eyes roll in their head. I do want to note, though, even with the PAGA reforms, that a lot of these reforms are beneficial to both the employee and specifically to businesses. How I like to think of the PAGA reforms is sort of like the union laws and labor laws that were passed in the 30s, 40s, and 50s. We had a lot of laws granting a lot of rights, and then as those laws started being used, we realized that, we need to pull back some of that, or we need to put a couple more borders in to protect everybody from how this law is being interpreted. And that's how I see the PAGA reforms. So PAGA was originally in effect starting on January 1st of 2004. And what this did is that it gave employees the ability to file lawsuits on behalf of the state of California for labor code violations, meaning the state said that it can't go out and just find everything that's not going well or not being followed properly. So they opened up the ability for employees to start the legal process. PAGA is the California's Private Attorneys General Act. And what the PAGA reforms did is that it changed and addressed the concerns about the abuse of the system and the excessive penalties that were being imposed to employers. Similar to the 4 labor union acts in the federal government, the reforms brought everything back into a more controlled manner. So it enhanced the right for employers to cure violations, meaning that if an employer with fewer than 100 employees could show that they understand that something was not correct and that they have a proposal to fix the said issue, they could submit that to the Labor and Workforce Development Agency and work towards correcting that instead of getting into a legal battle. Let's review what those reforms are. The first one we have is the enhanced right to cure violations. And this is for small employers with fewer than 100 employees. It allowed them to submit a cure proposal to the Labor and Workforce Development Agency, which means that they can say, we understand what the issue is, what the violation is, but here's our proposal to fix that and to correct any violations that have occurred. The next one we have is the penalty caps and adjustment. What this does is that if an employer who has not yet received a PAGA notice, but they are aware that there is an issue or a violation, if they take all reasonable steps to comply before receiving that notice, their penalty will be capped at 15%. Additionally, if an employer receives the notice, but they take all the necessary reasonable steps to be in compliance within 60 days of receiving that notice, their penalty is going to be capped at 30%. It also put caps on any penalties for minor, isolated violations. We also saw reforms to the narrowing of the standing to sue, which means that it limited the broad reach that was previously allowed, where one employee could sue on behalf of all workers for various unrelated violations. Now, employees must demonstrate that they personally experienced the alleged violations. We also see the elimination of stacking penalties. Employers are no longer to multiple penalties for the same underlying violation. We also see an increase to the employee share of penalties. Before, lawyers would receive 1/3 off the top of the penalty that was assessed, where after that, 75% of it went to the state and only 25% went to the employees who experienced the violations. This increases the share of penalties to the employees by 10%, so they now receive 35% instead of 25%. It also set a statute of limitations. The statute of limitations now is set to 1 year, so that equals 1 year and 65 days before a PAGA claim is filed. Now, we talked about the reasonable steps. The reasonable steps that the law says should be taken to reduce the likelihood of violations is supervisor training, also making sure that a business is taking the appropriate corrective action when a supervisor is violating the protections, that employers are doing payroll, wage, and hour audits, meaning you're auditing the sick pay, meal, and rest breaks, overtime, the rate of pay, and that pay stubs are created following all laws. And the handbooks and policies are updated, and not just that they're updated, but we are making sure that those updates are making it out to the entire workforce. Now, all of these should be updated regularly, and there's no definition of what regularly is, but you should at least be doing these 3 things annually. Other things that we want to note are best practices is that arbitration agreements are allowed in the state of California. So, arbitration agreements are legally binding contracts that waive the right to sue in the event of a dispute. Employers can require arbitration agreements as a condition of employment in California. Now, this was back and forth for a little bit, so I know that this one might be confusing, but we know that in January of 2024, a court ordered a permanent injunction that allows arbitration agreements in California workplaces. Now, even though that they are allowed, arbitration agreements can be unenforceable if they are unfair or improperly worded. You should be working with an employment lawyer in order to write an appropriate and legal arbitration agreement. Another best practice is having meal period waivers. So, what is a meal period waiver? That is a signed agreement between you and an employee to waive the 30-minute meal breaks that are required as a part of California employment law. Now, there are two different meal breaks that are in there. The first one we have is that any employee who works more than 5 hours is required to have a 30-minute meal break. A second meal would be if a worker works more than 10 hours, they would be required to have a second 30-minute meal break. Now, a meal period waiver, so this written agreement between an employer and an employee, says that an employee chooses to waive those meal periods in certain circumstances. Now, the first meal break, the one that if an employee works more than 5 hours, they are entitled and should have a 30-minute meal break, says that the employee can waive this if they work a shift that is less than 6 hours. So in this instance, a non-exempt worker could work 6 hours or less and not take a meal break. The second waiver would be if a non-exempt worker's shift is more than 10 hours but less than 12 hours, the worker can waive the second required 30-minute meal break. Now, I do want to note that an employee would not be able to waive both meal breaks in shifts lasting more than 10 hours. Again, this would be a written agreement that the employee is waiving these meal breaks so that way they are not elongating their day when they're working a shorter than normal shift or a shift less than 6 hours. Another best practice is having actual timekeeping. Now, what this means is that we want to make sure that we are using every possible manner in order to record the actual time that employees are working and not using any type of rounding system for arrival, departure, and meal break start and end times. The best practices for this are using a time clock or some sort of digital timekeeping that records actual time worked. We also want to make sure that we have automatic meal break penalties. Now, we were talking about the meal breaks before, and we were showing that if you work more than 5 hours, an employee is entitled to a 30-minute meal break. The meal break penalty would be if we do not allow the employee the full 30-minute meal break that's required. So if an employee clocks in and out of their meal break and it lasts only 29 minutes, then the employee is entitled to 1 additional hour of pay at the employee's regular rate of pay. One way to combat this is to have an automatic meal break penalty, meaning that your timekeeping system recognizes that a meal break was less than 30 minutes and automatically adds that 1 hour onto the end of that person's day's wages. A note for employers, one thing that can prevent this meal break penalty is enforcing a 1 hour or allowing a 1 hour meal break during the day. This also has to do with missed rest breaks. So if a rest break is missed, it not given, or is interrupted, then an employer would owe the employee 1 hour of pay at the regular rate of pay, which must be included on the next paycheck. So having your timekeeping system recognize that these are not happening, these breaks are not happening as they should, having the timekeeping system automatically adding those hours onto the employee's timekeeping. We see that these meal break penalties are the majority of the PAGA lawsuits out there right now. The last best practice is no off-the-clock work. This includes texting, calling, or interacting with your employee off the clock for work-related matters. This is the greatest increase in current PAGA claims. Now, I know we are going through 2025 law changes, but I do want to touch on the fact that last year, effective July 23rd of 2024, the Indoor Heat Illness Prevention Law went into effect. Now, this law states that you need to have a plan, an employer needs to have a written plan on what to do if your indoor workplace gets hotter than 82 degrees Fahrenheit, and then additional steps that need to be taken if your workplace gets above 87 degrees Fahrenheit. So with this, your heat illness prevention plan should have training and steps of what you will do as an employer to prevent heat illness for your employees. So once you get over 82 degrees Fahrenheit inside, your workplace should provide fresh, pure, and suitable drinking water. That you should have cool down rest periods and also help new employees with acclimatization. Once you get over 87 degrees, you need to make sure that you're able to measure and record what those temperatures are, and that you have additional control measures, including being able to provide an area that is less than 82 degrees Fahrenheit for somebody to be able to cool down. I do want to note that Cal OSHA has a sample plan on their website, and the website information is provided in our show notes. And we just want to say that the Cal OSHA sample plan is really easy to use. It shows all the areas where you need to supply your customized workplace information in red. So it is really easy to go through and fill it in as needed. So what are our key takeaways today? Most agencies on the state and federal level will have guidelines and resources to help you with your required postings and even creating written plans. We also know that best labor practices include supervisor training, payroll, wage, and hour audits, and regular handbook and policy updates. List of resources. Most state-level Department of Labor websites have extensive employer resources for businesses, as well as complete listings and links of employment laws that are in effect in your state. Also, the federal employment law and resources on the DOL.gov website, Department of Labor. You can find topics, forms, and links that go out to many of the employment regulatory agencies that are in effect. We hope you enjoyed this week's episode. Send us an email at hrtoolboxpod@gmail.com to suggest topics and let us know what tools you are looking for to improve your workplace. Follow the HR Toolbox on socials at HR Toolbox Pod. Follow us to stay up to date with the latest HR Toolbox resources and news. See you in the next episode. Don't let anyone put a wrench in your week.